Late last month, an extraordinary moment unfolded at a judicial conference in San Juan, Puerto Rico, when a member of the Supreme Court openly chastised the current administration's approach to the judiciary. Justice Ketanji Brown Jackson, the Circuit Justice for the District, delivered a stark admonition to her colleagues. Federal judges face unprecedented threats and intimidation that jeopardize the very foundations of American democracy. Justice Brown Jackson's 18-minute address departed from the customary neutrality of such gatherings. She warned that threats and harassment are attacks on our democracy, on our system of government, and they ultimately risk undermining our Constitution and the rule of law. Urging her fellow jurists to summon raw courage and to dispense justice without fear or favor, she predicted that history will vindicate your service. These remarks mark a significant escalation in the judiciary's public defense of its independence and signal the acute pressures felt across the federal bench. The formal reproach follows a series of increasingly defiant statements from within the executive branch. At a White House cabinet meeting earlier this month, Secretary of State Marco Rubio brushed aside a request for information regarding the detained migrant Abrego Garcia. When pressed, he curtly refused, declaring, "I'm not going to give it to you. Judges will never get the information." Seated beside the president, Rubio framed his stance as a matter of executive prerogative. The conduct of our foreign policy belongs to the president and the executive branch, not some judge. His remark, delivered in a tone more befitting a political rally than a press briefing, underscores the prevailing attitude within parts of the administration that judicial oversight is an inconvenience rather than a constitutional requirement. Yet Justice Brown Jackson's address underscored that this defiant posture transcends any single administration. Judges appointed by Presidents Reagan, George W. Bush, Clinton, Obama, and Trump alike have voiced similar concerns. Chief Justice John Roberts has repeatedly sought to present a united front, urging the court to speak with one voice. Nevertheless, Roberts' efforts have been hampered by a torrent of public attacks and personal threats directed at judges at all levels. Two recent case studies illustrate the extent of this institutional friction. In Maryland, a Trump-appointed district judge issued an order facilitating the repatriation of Abrego Garcia, a Honduran national detained under a wartime statute. Simultaneously, in the Southern District of Texas, Judge Rodriguez, another Trump appointee, delivered a landmark ruling invalidating the administration's novel interpretation of the Alien Enemies Act. He found that the statute's text confines its wartime powers to conflicts with foreign nations, and that applying it to Venezuelan migrants, deemed trending hostile online, stretched it beyond recognition. By rejecting both the due process carve-outs and the broad war powers claims, Judge Rodriguez fortified the principle that no individual is above fundamental constitutional protections. These judicial interventions have provoked vehement reactions from hardline commentators and political operatives. Lone actors have issued Domino's Pizza treatments to the homes of federal judges, while certain senators have openly called for impeachment proceedings. According to legal observers, Jeb Boasberg of the District of Columbia has required 24-hour security detail, a reality starkly at odds with the once presumed collegial atmosphere of the bench. These instances of harassment exemplify a broader trend: aggressive, intimidation-based rhetoric aimed at deterring judges from checking executive excesses. At the heart of this conflict lies a fundamental question of separation of powers. The U.S. Constitution establishes a framework of checks and balances precisely to prevent any branch from accreting unchecked authority. Yet recent pronouncements from some in the administration, couched as assertions of tough guy sovereignty, threaten to erode that balance. Should the executive branch refuse to comply with judicial orders, the nation risks a constitutional crisis of the sort rarely contemplated outside academic treatises. Despite these alarming developments, the legal community has mounted a resilient response. Professional organizations, bar associations, and non-partisan watchdogs have rallied to support judicial independence. An overwhelming 85% of Americans now believe that if a court issues an order, the president must obey it, indicating robust popular backing for the rule of law. This public consensus bodes well for the judiciary's ability to withstand political pressure. Moreover, the judiciary itself has demonstrated remarkable endurance. Across the country, district courts have issued carefully reasoned opinions that uphold due process and preserve statutory limits on executive power. Even judges appointed by the current administration have joined their colleagues in affirming that the Constitution cannot be disregarded for expediency. In this respect, Chief Justice Roberts' aspiration for a unified voice has found purchase in the fidelity of lower court jurists, who continue to perform their duties with unwavering impartiality. As America approaches another pivotal election cycle, the judiciary's role as guardian of constitutional governance will only intensify. Legal scholars warn that a failure to respect judicial authority could accelerate a slide toward executive aggrandizement. Yet, the judiciary's recent performance offers cause for measured optimism. When confronted with threats, intimidation, or politically charged rhetoric, judges have responded with reasoned opinions, grounded in statutory text, historical precedent, and the enduring principle that no person or office is exempt from the law. In the final analysis, Justice Ketanji Brown Jackson's call to keep doing what is right for our country resonates beyond the bench. It serves as a clarion reminder that the rule of law is a collective enterprise, one that depends on the courage of judges, the vigilance of civil society, and the informed engagement of the citizenry. If history does indeed vindicate those who uphold constitutional limits, then the judiciary's steadfast defense today will stand as a testament to American democracy's resilience. Even amid relentless partisan pressures, building on the recent demonstrations of judicial resolve, it is essential to consider how evolving political and technological currents may further test the court's capacity to act as a stabilizing force. In the digital age, social media platforms have become catalysts for rapid mobilization, both in support of and opposition to court decisions. Viral campaigns targeting individual judges can foment harassment at an unprecedented scale, complicating efforts to preserve anonymity and security. The federal judiciary has begun exploring partnerships with technology firms to improve protective measures. But these solutions remain nascent and reactive rather than comprehensive. Concurrently, the global context illustrates the stakes of America's own struggle. In several established democracies, including India and Brazil, judicial rulings have sparked mass protests and executive backlash when courts have checked government overreach. Yet, in each instance, the durability of constitutional review ultimately depended on a broad consensus, the public's acceptance that courts serve as neutral arbiters rather than political actors. By contrast, recent rhetoric portraying judges as partisan adversaries threatens to erode that consensus before it can fully take root in the current administration's tenure. Looking ahead, emerging legal battles over executive privilege, surveillance authorities, and emergency declarations promise to define the contours of executive, legislative, judicial relations for decades to come. Pending before various district and circuit courts are challenges to unprecedented uses of classified evidence to justify covert operations, as well as lawsuits questioning the president's unilateral declarations of national emergencies for domestic policy ends. How these cases are adjudicated will reveal whether the judicial branch can maintain procedural rigor in the face of arguments invoking national security and executive independence. Moreover, the Supreme Court's forthcoming decisions on these and related matters will carry disproportionate weight. With a current bench divided between strict textualists and more pragmatic jurists, the institution's ability to speak coherently will again be tested. Justice Brown Jackson's exhortation to her colleagues to stand firm regardless of the political winds thus resonates with heightened urgency as the court prepares to issue rulings that could recalibrate the boundaries of presidential power. Ultimately, the judiciary's survival depends not only on the personal courage of its members, but also on structural reforms to bolster transparency and public trust. Proposals under consideration include mandatory disclosures of security incidents affecting sitting judges, enhanced funding for judicial education on digital threats, and a reaffirmation of bipartisan support for lifetime tenure as a bulwark against political retaliation. If enacted, these measures could help fortify the judiciary against the pressures of modern governance without compromising its constitutional role. In sum, the unfolding contest between executive ambition and judicial independence represents a defining chapter in American constitutional history. The ability of federal judges to withstand intimidation through reasoned jurisprudence, institutional solidarity, and public engagement will determine whether the rule of law endures as the bedrock of democratic governance or succumbs to transient assertions of power.